Hello, and welcome to the HSBA Senior Counselors Division's monthly coffee hour. My name is Jerry Chang. Our guest speaker today is Edmar Castillo, Compliance Assistant Specialist with the Hawaii Occupational Safety and Health, or HIOSH. The title of Edmar's presentation is Protecting Hawaii's Workforce, a regulatory view on HIOSH's compliance and cooperation. The presentation will cover the history, purpose, and goals of HIOSH law. It also explains how HIOSH is enforced and the cooperative programs it offers. Edmar has been a dedicated professional at HIOSH since 2015. He has conducted thorough investigations to ensure that organizations uphold HIOSH's minimum regulations. He also focuses on providing organizations with the information and resources they need to navigate regulatory requirements effectively. So please welcome Edmar.
Thank you for welcoming introductions. So this presentation is provided under the authority of Section 396-4C, as in Charlie, of the Hawaii Revised Statutes, which authorizes the Hawaii Occupational Safety and Health Division, otherwise known as HIOSH, to disseminate educational information to employers, employees, and our community. Through lectures, exhibitions, and other forms of public outreach, HIOSH aims to raise awareness about the causes and prevention of workplace accidents and injuries. I'm your host, Edmar Castillo, and a HIOSH Compliance Assistant Specialist, otherwise known as CAS. In my current role, I provide general guidance on HIOSH laws and work closely with businesses and the community to promote safety-minded practices. So since joining the agency in 2015, I have served as the Compliance, Safety, and Health Officer, for short, CSHO, where I audited local businesses for compliance efforts, as well as a former whistleblower investigator safeguarding employees' rights to voice concerns about workplace safety. And as a disclaimer, this presentation is for educational purposes only and is not a legal document. For full legal obligations, please refer to the official HIOSH laws and regulations at labor.hawaii.gov/HIOSH. So in this PowerPoint, I will explore 4 key topics related to occupational safety and health. First, we'll dive into the purpose and background of occupational safety and health. So understanding the historical context and foundational principles briefly, because it's essential for understanding its significance in protecting workers' rights and well-being. Next, we'll also examine the compliance side. I'll discuss briefly the regulations that organizations must comply to meet the bare minimum requirements. I'll also discuss the implications of non-compliance and what employers can implement into their workforce. Third is cooperative programs. This is my area. So these initiatives foster collaboration between employers, employees, and other regulatory bodies to promote safety in a workplace. I'll share some examples of our successful programs that have made a difference in our Hawaii community, and I would love for you all to be a part of this as well. And finally, we will look at the resources available to you folks through the community. This includes informational materials and support services aimed at enhancing workplace safety awareness. So, the purpose and background of occupational safety and health. He kuleana ko kako. That means we all have a responsibility. And here at HIOSH, that means working together to prevent the workplace injuries through shared commitment to safety, health, and respect in every workplace. Because workplace safety laws in the US and Hawaii develop over more than a century of industrial disasters and reform. It culminated in the creation of the OSH Act in 1970s and the HIOSH Law in 1972. This is to enforce and promote safer working conditions. As you'll see in the orange, there have been key tragedies and others that with growing public health efforts and progressive legislation at both the state and federal levels that drove to the evolution of these worker protection safety laws. And workplace injuries and illnesses don't just affect employees, they also hit you, the businesses, hard pretty too. When someone gets hurt on a job, it often leads to lost work days, reduced productivity, higher insurance premiums, and sometimes even lawsuits or government fines. And in most cases, it can damage your reputation as a business set in a community-oriented state like Hawaii, or lead to the loss of federal contracts if you're in the construction business bidding for federal jobs. So that's why Congress created the OSH Act, and Hawaii legislators followed in suit. The extension of that is HIOSH law to help prevent these kinds of disruptions before they can happen. After all, the goal isn't just to enforce rules for the sake of rules, but to protect you folks, the people, and to keep businesses running smoothly and maintain a level playing field. A safe workplace means fewer accidents, lower cost, more consistent operations, and ultimately stronger business outcomes. So by following HIOSH law or the OSH Act, if you're in the OSHA's jurisdiction, employers are investing in long-term stability, ensuring that you do take your responsibility as an employer seriously, because compliance isn't just a legal obligation, it is a smart business move. So I'm saying a lot about OSHA and HIOSH, but what does it mean? Well, when it comes to workplace safety, it's also important to know who enforces the rules depending on where and for whom you work. Under federal OSHA, they exist nationwide and they set the safety and health standards for all U.S. workers. In Hawaii, though, federal OSHA has only jurisdiction over federal agencies like military bases, USPS, TSA, and federal property like national parks and certain airports. Well, they do cover safety and health regulations in the workplace, as well as enforce like 25 anti-retaliation statutes, which I'll be discussing shortly afterwards, which protects workers from retaliation when they report violations. Here at HIOSH, however, we do operate only in Hawaii under a state-run plan approved by OSHA, and we have jurisdiction over private businesses like your restaurants, your hotels, construction, all that, as well as city and county and state agencies, your DOE, your uh, Department of Agriculture, all that. Okay. We also, just like federal OSHA, we also cover both the safety and health regulations, but we only enforce one anti-retaliation statute. Again, I'll show you in a little bit. But regardless whether or not you fall under OSHA or HIOSH jurisdiction, the ultimate goal of HIOSH and OSHA laws is simple but powerful: to prevent the first accidents from ever occurring. And this isn't just a slogan, it's the foundation of the law itself. Because the purpose of the law is to prevent harm before it occurs. That's why a HIOSH is not required to wait for an injury or a tragedy to issue a citation. In fact, HIOSH does not need to show that someone was hurt at all in order to hold the employer accountable. The law is designed to address unsafe work conditions as soon as they are identified, because waiting for an injury defeats the very intent of workplace safety regulations. And this is me trying to understand my audience here for all you attorneys, especially personal injury lawyers. I think you guys call this foreseeability, to prevent things or to take proactive measures before something happens, if I am to understand it correctly. So, in other words, the law is meant to prevent future injuries by taking action now. And for employers, that just means being proactive and not reactive. It also means to inspect equipment before it fails, to train employees before they're exposed to hazards, and to correct unsafe practices or environments before they result in harm. And with that, it also means a whole mess of things where you want to foster a culture where safety isn't just compliance, it is a shared responsibility. Because when employers take initiative, empower their teams, and actively work to eliminate risk, they're not just following the law, they're honoring the very people who keeps their operations running every day. And so employers, I get it. Like employers face a lot of significant challenges when trying to comply with HIOSH laws, trying to run a business, market pressures, economic shifts, labor shortages, and even unpredictable job site conditions. And I get it. These difficulties, when you really trace it back to just three main issues, is ignorance, ineptitude, and incompetence. And I don't mean to sound harsh, but they do reflect a real common barriers to effective compliance that ultimately affect worker safety, starting with ignorance that refers to a lack of knowledge about the laws, regulations and responsibilities by HIOSH. And many employers, especially in small or newly established businesses, they're just simply unaware of the regulations that apply to their industries, to their business, or specific work activities. They may not even know that certain practices are unsafe, or they may be unaware that specific regulations even exist, like HIOSH. So this lack of awareness can lead to unintentional violations and missed opportunities to create a safer workplace. Ignorance is not always willful. It can stem from just basically having limited access to training, resources, or guidance, especially in remote or the underserved communities here. However, as what I'm been told by a lot of attorneys is that ignorance of the law is not a legitimate defense. And someone can correct me there if I hope I said it correctly. But regardless of the cause, employers are still legally obligated to be well informed and to take reasonable steps to protect their workers. Second is an ineptitude. So that involves having some knowledge of HIOSH regulations, but failing to apply it correctly or consistently. That's, for example, an employer might understand that they may need to provide personal protective equipment, like PPE for short, for example, but they may choose the wrong type of PPE or they neglected to maintain it or it's aging, it's failing to ensure that employees are actually using it. And it's this kind of gap between knowing and doing can result from poor planning, unclear policies, or a lack of internal accountability. Ineptitude often reflects the systemic issues within the company, the organization, such as weak leadership, ineffective communication, or just disorganized safety management systems, which I'll discuss shortly about the safety and health management systems that you, as businesses, can implement into your organization. And finally, incompetence. This reflects a deeper inability to fulfill your legal and ethical responsibilities because even when you have the knowledge and resources available, you could still fail because to correct known hazards by disregarding employee concerns or just willfully neglecting to train supervisors adequately. Incompetence may come from a culture where they don't value safety of their employees or where individuals in leadership roles who lack the skills, qualifications, or motivation to enforce compliance in their organization. And over time, this can create an environment where risks become normalized and violations become very routine with the organization. So keep in mind, there are certain HIOSH regulations that we do require a competent person. That's one that has been designated by the employer, uh, one that is able to recognize hazards and having the authority to fix them, such as fall protection, excavation, cargo hooks for helicopter, welding, and so many more. So ultimately, these three common root cause barriers, ignorance, ineptitude, and incompetence, they do help explain the root causes of noncompliance, but they don't re relieve an employer of their responsibilities under HIOSH law because the law is clear. Employers must take reasonable steps to recognize, evaluate, and control workplace hazards. And to meet this, businesses must invest in education to build strong safety systems and lead with accountability because worker safety is not optional and neither is compliance. So how do we do this? So HIOSH, our office, is made up of two main divisions, each playing an important role in keeping workers safe. One is what we call compliance, which is like the hammer. It's about enforcing the law. This includes safety and health inspectors or COSHOs who conduct inspections to identify hazards in the workplace and make sure that employers are following the rules. It also includes whistleblower investigators who step in when workers report retaliation for speaking about safety concerns in their organization. And the other side is known as cooperative programs, where I am based in, and it's best thought of as a toolbox. So instead of focusing on enforcement, we offer support, guidance, and incentives to help businesses go above and beyond the basic legal requirements. And these programs, I'll talk about in a little bit, they're designed to build strong safety cultures, recognize high-performing workplaces, and provide you folks resources for those who want to improve voluntarily. So together with the hammer in a toolbox, it represents HIOSH balanced approach, holding employers accountable when necessary while also offering the tools and support to help them succeed in creating a safer workplace. So if you think compliance is expensive, try non-compliance. This quote emphasizes the high costs associated with non-compliance, such as fines, battles, and reputational damage, highlighting that investing in compliance is often a more cost-effective strategy for a lot of businesses. HIOSH regulations here, if you scan the QR code, this will lead to our Hawaii Administrative Rules. It outlines the regulations that employers are obligated to follow in order to protect your workers from the hazards. So the regulations encompass various sectors like construction, agriculture, and general industry. General industry comprises of, well, the generalized industries like restaurants, hospitals, and so forth. These regulations establish limits on, say, workers' exposure to harmful chemicals or mandate the implementation of specific safety practices and equipment and require employers to keep track of hazards as well as maintain records of workplace injuries and illnesses. Um, and I want to make it a point that these rules are regarded as the bare minimum that employers must follow in order to ensure a safe working environment. And of course, employers are expected to go above and beyond these basic requirements by implementing additional safety measures tailored to their specific industry and businesses. So in doing so, hopefully this proactive approach not only safeguards employees, but also fosters a culture of safety within the organization. So some examples that I'm not going to dive into in the 1 hour that I have, but they include, but not limited to, the fire safety, forklift operations, power equipment tools, hazardous chemicals usage and storage, exposed electrical wiring, ladder safety, training requirements, and to prevent hepatitis B for sometimes healthcare workers or whoever works with syringes or whatnots, okay? Um, and I do want to add that, moreover, most of the HIOSH regulations align with the 2017 edition of the OSHA regulations, meaning we adopted the 2017 version, and it might take a while for us to uh, adopt federal OSHA's regularly revised regulations. So please keep connect with me just after this if you want to know more. And finally, we do have Hawaii exclusive rules, in which we'll see in a little bit. So, in addition to the existing HIOSH regulations, employers are also required to follow the General Duty Clause, the GDC. And this clause is was established to address serious hazards that lacked specific regulations. For example, occupational heat stress, which can occur when employees face conditions that put them at risk for heat exhaustion. Another is workplace violence and other situations that might come up because there's no dedicated standard. And compliance officers from HIOSH may issue citations for these issues. So this is what the GEC language is for general industry, which is applicable for all industries except construction. Construction has a relatively same or similar language, but this is the cited standard that we would use for general industry. So I'd like to take a moment and highlight the differences in the language between uh, the the GDC of OSHA's federal OSHA standards and our HIOSH office. While both clauses aim to ensure worker safety, there's a different emphasis and wording that slightly has different approaches. So under federal OSHA, the general duty clause primarily serves as a broad legal obligation where employers must provide a safe workplace that's free from recognized hazards that are likely to cause death and serious physical harm. So the focus here is just hazard recognition and employers' duty to prevent harm, but it doesn't exactly prescribe the reasonable steps to eliminate or mitigate hazards, compared to the HIOSH General Duty Clause. The GDC here, this takes a step further by placing more emphasis on abatements, the process of actively addressing and correcting hazards. So rather than simply requiring employers to maintain a hazard-free workplace, whatever that means, HIOSH version outlines a more action-oriented framework that encourages employers to take these specific steps to fix or reduce hazards not otherwise covered by existing standards. In fact, the HIOSH General Duty Clause closely resembles the NIOSH hierarchy of controls, and this also serves as a proactive abatement-focused framework for you folks to identify and reduce workplace hazards. This encourages employers to analyze risk and implement this layered practical solution based on this framework. So your elimination, that's um, instead of to prevent ergonomic hazards among your employees, maybe think about automating a repetitive task or just not using toxic chemicals just to eliminate the hazard itself. You can implement a substitution, which is replacing solvent-based paint with water-based or using correlates tools instead of corded tools to reduce trip hazards. Engineering controls, that's machine guarding on table saws, soundproof enclosures for really loud environments, establishing ventilation systems in the event that there's a lot of chemicals in their environments, administrative controls, that's your conducting periodic safety training, drills, rotating shifts. Another example is to avoid heat stress. Employees start their shift sometime around like what, 3 in the morning and finish just before the hot 12 p.m. afternoon on a summer day, just to prevent getting heat exhaustion. And finally, PPE, just issuance of gloves, face shields, and all that. So this is a structured approach to promote continuous improvement and help employers not only meet their legal obligations, but just build a more safer, resilient work environments. I do want to show that it's important to understand that the best way to manage risk is through elimination because we could just remove the hazard entirely, right? uh, there can be no chance of employee exposure. On the other hand, if you see this diagram, that PPE is the least effective measures because it tends to be costly for businesses to buy and supply PPE to the workers, but also employers have to monitor that employees are properly using it and consistently using it, which can prove additional challenges for employers. So just take it with a grain of salt. So you're probably wondering, well, how does HIOSH enforce all these standards and regulations that employers are subjected? Well, we enforce standards through inspections. These inspections are prioritized based on the severity of the situation. First and foremost, inspections are conducted in cases of imminent danger where there is an immediate risk to life or health of the employees, such as situations where someone is on the verge of dying due to unsafe conditions. Next in line are incidents involving fatalities where a worker has already lost their life due to work-related incidents. And these cases demand urgent attention for us to rush out and to prevent future tragedies with other employees. And HIOSH, our office, we respond to complaints filed by employees who report unsafe working conditions. Um, Referrals that can also originate from various sources, like we have partnerships with medical examiners, firefighters, other co-shows, and even employers themselves, because sometimes the employers, if something happens in their workplace, they are legally obligated to notify us within a certain time frame, either an amputation, loss of an eyeball, inpatient hospitalization, or even worker fatality as well. And finally, there are program inspections. This is a list of employers who have workplace injury rates that are trending or remain higher than the average industry levels. And after the selection criteria to do the inspection, the HIOSH inspection process includes the following steps. One, showing our credentials to confirm identity with the employer and other management officials as well. Two, holding a a what we call an opening conference with employer management and sometimes union rep to set expectations as to how the inspection process goes. Three is to conduct a walk around where we are touring the establishment with management officials, where we ask for company documents like the safety and health program, fire safety, all that. We interview employees privately, collect samples, or monitor things like certain noise levels in the environment with our dosimeters, and take additional photos or videos if necessary. And lastly, four is conducting a closing conference with the employer or union rep, depending, to summarize our findings. And from there, sometimes HIOSH might not give a citation if they find no issues or lack enough evidence, and instead they may send a hazard alert letter to the employer advising them on how to fix specific problems. But in other cases, HIOSH may issue a citation with monetary fine starting at roughly $16,000 for each violation and up to $165,000 for willful or repeated violations. And remember, these fines will increase each year due to the Federal Civil Penalties Inflation Adjustment Act. So just be aware. And following HIOSH laws, the specific rules and the general duty clause is important, but just doing the bare minimum isn't enough to keep workers truly safe. The laws and regulations only cover known hazards and often come into play after problems happen. So in other words, it is reactive. So if employers stop at basic compliance, they may still leave workers at risk. But to truly build a strong, reliable safety culture, employers need to go above and beyond the minimum by creating what we call a safety and health management systems, SHIMS for short. This is a proactive, full plan that makes safety a part of the company's everyday operations. It helps companies prevent problems before they happen, and it shows that the safety is a core value and not just something that matters when it's convenient. So a good safety and health management system includes, and you're going to hear this over and over, is strong leadership where leaders actively support and buy into the safety culture by setting clear goals and provide resources and modeling safe behavior for their workers. Work involvement, where workers are involved in every aspect of the safety program and are empowered to report concerns without fear. And if you have a union rep, you also want to involve them to get their feedback as well. Conduct regular safety checks and implement hazard controls and preventions. And hey, that's what we just talked about, the general duty. It's all relatively the same. Training and making sure that everyone receives training to understand their safety roles and to recognize hazards and apply protective measures. The program evaluation and improvement. So this program is requires the employer to routinely review certain track performances, correct issues, and improve overall safety. So an example of key metrics is what we call the average resolution time, or ART for short. And it's a measurement where you measure the onset of safety concerns reported to its resolution. Another key performance metrics is the examination of workplace injury rates from your, say, OSHA 300 forms and 301 data, uh, 300A data. So employee engagement. Another is the employee engagement in safety meetings. How active are employees in the meetings, really engaging with you when you host meetings? Are they listening with full intent and actually contributing to the overall forum, or are just waiting for this meeting to be over with, you know? So legal compliance is the first step, but the safety and health management system is really what builds a lasting culture of prevention, and it turns safety into a regular part of doing business, not just a rule to follow. So that's it for the compliance side. I want to talk about the whistleblower protection. There is the anti-retaliation that I mentioned earlier, where um, there's the whistleblower provision into the law. This is to protect employees from retaliation for reporting safety deficiencies or just participating in HIOSH proceedings, for example. Kina ole is the Hawaiian word of doing the right thing in the right way at the right time in the right place to the right person for the right reason with the right feeling. And that I feel that perfectly aligns with the spirit of the whistleblower protection laws. These laws are rooted in the belief that workers should be empowered and protected when they speak up about unsafe or unlawful practices. And I want to make sure that everyone understands that HIOSH, we don't focus on protected classes. Instead, we focus on those that engage in protected activity. Protected classes are groups of people, just FYI, that are discriminated on the basis of race, color, religion, sex, all that. And here, the Hawaii Civil Rights Commission, the HCRC, has jurisdiction on this matter. HIOSH, on the other hand, has jurisdiction on workers that speak up about unsafe work practices and in return was retaliated by their employer. And I just want to take the time to highlight the differences between federal OSHA's whistleblower statutes. There's like 25 of them versus HIOSH whistleblower statutes, where federal OSHA conducts investigation if one is to report, say, criminal antitrust violations from retaliation by their employers, then that's covered by the Criminal Anti-Retaliation Act. So another is protecting employees from retaliation for engaging in activities like reporting to EPA related to safe drinking water quality. But here in Hawaii, if your whistleblower complaint falls outside of the jurisdiction of HIOSH, just be sure to reach out to federal OSHA within the specified number of days listed here following the latest adverse action that they experience. And I'll talk about adverse action in a little bit. So, HIOSH law protects employees from retaliation for exercising their rights under the law. And examples of protected activity includes the following list, but it's not limited to this. So, expressing safety matters to management personnel, complain to HIOSH, participate in a HIOSH inspection, refuse to operate unsafe machinery, or refuse to engage in unsafe practices and violations of the HIOSH regulations and standards. And notice that I put an asterisk next to the refusal part because in the next slide, if a whistleblower were to claim successfully employee refusal, well, to claim successful employee refusal, they have to fulfill all these elements of this criteria to successfully claim it. So, has a reasonable apprehension of death or serious injury, and refuses in good faith, and has no reasonable alternative, where in this case, the employer if you refuse uh, task A because it's allegedly um, hazardous, then the employer has to provide task B as an alternative to that. So that's an example. Um, Next is has insufficient time to eliminate the condition through regular storage statutory enforcement channels. And this means like contacting us. If you have time to contact us, then that means you had enough time to eliminate the hazard by talking to us. And finally, where possible, sought from his or her employer and was unable to obtain a correction of the dangerous condition. And again, these are all elements that the employee has to meet to claim successfully employee refusal. Because typically, uh, the employee, the whistleblower can never walk off the job as a show of refusal because typically hazardous conditions may be corrected by the employer when you notify them, and as well as employee can still request inspection by us if corrections are still not accomplished. Therefore, what we tell whistleblowers like, yo, never walk off the job because you can still be disciplined for walking off the job, okay? These are the key parts that make up a case for retaliation with our office, and I'm going to try explain it in a simple, clear way. It starts when the employee takes part in a protected activity, like I mentioned earlier. For example, reporting a safety concern or filing with a complaint with HIOSH, or just um, speaking about a workplace hazard. Second is the employer is able to deduced which worker was responsible for speaking up to HIOSH. And after that, the employer takes some kind of adverse action against the worker. This could be like your firing, your demotion, the cutting hours, harassing them, or any sort of other punishment. And finally, there needs to be a clear connection or what they call a nexus between the worker's protected activity and the employer's adverse action. In other words, it needs to be shown that the worker was treated unfairly because they spoke up. And all of these steps together form the basis of a retaliation claim. These are the list of appropriate reliefs for those that blew the whistle under their employers. One is the rehiring the employee as a new hire. Second is reinstatement of the employee and restore them to their previous position with the same terms and conditions. And finally, uh, it lists other appropriate relief, and this is based on a case-by-case basis. And just like the safety and health management system, which is equally essential, to be to have an anti-retaliatory program, employers must implement this to avoid engaging in retaliatory behavior. So one, like I mentioned earlier, it's very important for management to show commitment. They need to lead by examples to prevent retaliation and uphold the laws as well as their own company policies and to for this. So their commitment to values should be demonstrated through their actions and not just words. Therefore, written policies need to be active practice and enforcement to be effective. And all the managers needs to be held accountable for responding to employee concerns. This includes addressing reports of violations, safety hazards, and yes, even retaliations itself. Second is compliance concern response system. Employers need to create a culture that values um, raising workplace concerns. So this means listening with empathy and addressing compliance concerns is absolute necessary. So if to start, create procedures for employees to report concerns, either confidentially or anonymous submittal, and ensure that it will be evaluated fairly, transparently, quickly, and effectively. And ideally, collaborate with workers and their union representatives. Third is anti-retaliation response system. You're gonna want to develop an independent reporting channels so that employees that experience retaliations, they don't claim retaliation to their alleged retaliatory manager, but rather they can go to another impartial staff. So really clearly define the roles that managers and the rest of your HR staff have in handling these kinds of reports. Fourth is anti-retaliation training, training all staff, like management and subordinates, with the knowledge and skills and tools that they need to recognize, report, prevent, and address hazards and retaliation. And obviously, the training must be provided in a language that all employees can easily understand. And finally, program oversight. So, with any other program, it needs to be continuously evaluated and ensure that the program itself is improving and modified as needed. In other words, conduct auditing, ideally by individuals who are also independent of the entire program as well. Now, the next part is cooperative programs. There's a whole old Hawaiian proverb, Pupakahi I Holomua, and that's roughly translated where united to move forward. And opposite to the compliance side, cooperative programs, again, we offer support, guidance, and incentives to help businesses go above and beyond the basic legal requirements. These programs are designed to build strong safety cultures and recognize those high performing workplaces and provide resources for those who want to improve voluntarily. So one of our many programs is the Hawaii Voluntary Protection Program. This is an initiative where we literally award organizations that demonstrate exemplary and self-sufficiency in safety and health management systems. Hey, that's what I said earlier, right? SHIMS. So this is specifically for private and public sectors, excluding federal, because we can't enter federal. And a key advantage to those award recipients is they will not be included on the HIOSH program inspection list. That's what I mentioned earlier, where it would be the least of our inspection priorities, but they would still be removed if they are the award recipient of this. And as of now, because this award program has been in existence for so many decades, only two organizations currently have been awarded, and they're still on our roster. But I'd like to see all you folks on this award program as well. So our winners, they're guided by several principles: voluntarism, cooperation, going above and beyond the minimum compliance, hazard prevention and control, and whatnot. So these principles underpin the program's goal of promoting proactive safety and health management systems in place. And these are our approval criteria. And to see more, just please scan the QR code, okay? Next is another award program that we provide, or rather the consultation and training provides, where they recognize small businesses for their outstanding safety and health programs. So this award is for those with small businesses. Fewer than 250 employees on site and fewer than 500 employees company-wide. And similar to the VBP, a key advantage of this program is that recipients will not be included on the HIOSH program inspection list. And unfortunately, as of right now, no businesses have ever received this award. But again, I'd like to see all of you sign up. And here's the eligibility requirements to be approved for this. For more information, please scan the QR code. Third is the HIOSH consultation and training branch. They provide assistance to small businesses, again, those fewer than 250 employees and fewer than 500 employees corporate-wide, free confidential services to help them comply with HIOSH regulations. You can contact them, okay? And plus, they're the ones that administer the SHARP program. Alliance program. So this is the community-led program where we collaborate with all of you guys with the goal to enhance workplace safety and health. This collaboration focuses on developing and delivering a training curriculum, for example, or sharing information about hazards and the best practices to address these hazards, as well as educate workers, the community, and employers about their rights and responsibilities. So come join me in this if you're interested. Like I mentioned earlier, organizations have the opportunity to collaborate with us on two initiatives aimed at benefiting the community. One that involves educating the community or industry about best practices, while the other focuses on outreach and communication, which includes developing informational materials or disseminating those said materials to the community, or you can do both. Available resources to help employers comply or rather understand the HIOSH law better is we have high tools. So if you go online on our website, these are interactive tools that I created to help employers navigate their regulations better, such as what's considered recordable injury under HIOSH, or if your company is required to electronically submit workplace injury rates to OSHA every year, am I eligible for that? Okay, so that's available for you folks. And last, we have Request a Speaker, like me, where you can request me for other speaking events. To express your interest, please scan the QR code or simply just search for Request a Speaker on our HIOSH website. And I want to thank you to the Hawaii State Bar Association for this opportunity to provide general information about HIOSH law and the HIOSH agency. And we're looking to help our community in any way. And I hope to have you folks submit an anonymous survey telling me what you like about this PowerPoint, what can be improved, and what you'd like to see in the future. And separately, I provided my email. If you want to email me, I'll keep you guys informed of future HIOSH workshops in the future, like record keeping and whatnot. Thank you.
Thank you, Edmar. If there's any question in the audience, please, you can put them in the Q&A box function, and then we'll read it out loud, and then Edmar will answer it for you live. But let's see. Let's give it a couple minutes for people to submit their questions. If there's any, if, all right. Seems like there's not many no questions coming in. Well, they do have your contact information on the slide, so they'll probably email you these questions privately at Marv. But Yeah, I want to say thank you for giving your time for your presentation, and then I want to pass it over to Jerry for some final words.
Okay, again, thank you, Edmar, for your excellent and informative presentation. So for everyone, please join us at our next coffee hour, which I believe is on August 7th.
Yes.
So with that, aloha and have a great weekend.
All right. Thank you, everyone.
Thank you all.
Thank you, Edmar. Appreciate your help.